Hello students, please subscribe the channel, drop a like, share and comment. This is exercise number 26 of the Progressive Monthly Magazine, December 2022 on the speed of 100 words per minute. Start. The prosecution and the complainant will also, of course, be given an opportunity to examine their own witnesses and to cross-examine the witnesses who have been got examined on behalf of the accused, and for that purpose notices of the proceedings before the J.J. board shall be served on the complainant. As it is possible that in some cases the prisoners mentioned in the state's list may indeed be below 18 years in age on the date of offence, but as the basis for arrival at the conclusion in the state's list were usually some preliminary medical examinations and no detailed steps for ascertaining ages had been taken after hearing both parties, and it cannot be ruled out that in certain cases extraneous measures may have been used for reducing the ages. We think that such an exercise as detailed above, wherein the ages are ascertained after hearing both parties, was needed. The said exercise is to be completed within a period of 2 months, and the reports submitted to this court on its next listing. The district judges or district legal services authorities shall take strict measures in future for ensuring that prisoners below 18 years of age on the date of offence are not lodged in adults' prisons in violation of the Juvenile Justice Act and rules. So far as District Allahabad is concerned, we direct the District Judge Allahabad to permit Rohan Gupta, advocate, to visit and interview the concerned prisoners for the purpose of ascertaining their ages and for submitting the report to the court on the next date of listing. It was further submitted by the learned counsel for the petitioner that so far as the prisoner Raju is concerned, whose age was determined to be below 18 years, he was earlier lodged in Faizabad jail and was subsequently sent to the special home, as he was convicted as far back as in the year 2001 in a case under Section 302 IPC. The respondents should inform this court about the total period spent in jail by this prisoner, and in case it exceeds 3 years, the basis for his being presently detained in the special home. Thus, while the order referred to above passed in a public interest litigation being criminal, the Allahabad High Court directed the Juvenile Justice Boards to hold an inquiry for determination of the age of prisoners. The medical board subjected the writ applicant herein to the x-rays of the skull, etc. Upon medical examination of the writ applicant herein, the medical board gave its report certifying that the date of the commission of the alleged offence, the writ applicant could have been around 15 years of age, as on the date of the medical examination the convict was around 56 years of age. It appears that sometime later the writ applicant was in a position to obtain a document in the form of family register issued under the UP Panchayat Raj Rules 1970. In the family register certificate, the year of birth of the writ applicant herein is shown as 1968. If 1968 is the correct birth year of the writ applicant herein, then in 1982 he was about 14 years of age. In such circumstances referred to above, the writ applicant is here before this court. He claims that as he was a juvenile on the date of the commission of the alleged offence sometime in the year 1982, he could not have been put to trial along with other co-accused and should have been dealt with under the provisions of the Juvenile Justice Act as prevailing at the relevant point of time. It is the prayer of the writ applicant that the respondent state be directed to get the claim of the writ applicant in regard to the juvenility verified through the concerned Sessions Court or the Juvenile Justice Board. Mr. Rishi Malhotra, the learned counsel appearing for the writ applicant, vehemently submitted that although till the dismissal of the special leave petition by this court wide order, the convict had not raised the plea of juvenility, yet the law permits him to raise such a plea even at this point of time, having regard to the provisions of the Juvenile Justice, Care and Protection of Children Amendment Act 2011. It is submitted that there is clinching evidence on record as on date in the form of certificate issued by the medical board as well as the family register to indicate that in the year 1982 the writ applicant could be around 15 years of age. The learned counsel would vehemently submit that there is no good ground to discard the certificate issued by the medical board as well as the extract of the family register. To fortify the aforesaid submissions, the learned counsel seeks to rely upon a three-judge bench decision of this court in the case of Ghulam Hussain versus State of West Bengal, reported in 2012 10 SCC 489.